Here we go. Getting everything sorted out. Yes, hello, hello, everybody. Hello, welcome, welcome, welcome. Hi, hi, hi. Let me get my sticky note going. Hopefully, is the camera close enough, everyone? Should we get it a little bit closer, or are we good? Let me know. Hello, hi. Hello, Mo Girly Girl. Cynthia, Queenie, hello, Kimberly. A girl with her brushes, nice. Good to see you. Alan, welcome, welcome, welcome. And okra and sweet tea, that sounds nice. Oh my gosh, welcome in everyone, welcome. Good to see you. Hello, Meme NATO. Every time, seriously, I see your name, I just am like, I need to start watching those Sharknadoes movies again. I tell you, they're the only things that got me through some dark, dark days. Dark, dark days. Let's get a chainsaw and take care of some business. Hello, hello. Hi, Kaya. Navy Vet. Good to see you, Alice. Hello. Well, I can't help it, everyone. Seriously, Sharknado. If you're having a bad day, go watch the Sharknado. You'll feel better. Oh, my goodness gracious. I think I need something strong. Well, yes, we all do. We all do. Hello, Nancy. Good to see you, Kat. Welcome, welcome. And let's see, Mrs. Hazy, or is it Mr. Shazy? Oh my goodness. Sorry about that. Oh my gosh, that's so funny. Oh, I just love all the names. I love them. I love them. I love them, everyone. Oh my gosh. Really? Tremors? Okay, okay. Mrs. Hazy, all right. Well, I'm glad. I knew it was Mrs. Hazy or Mr. Shazy. Just wanted to make sure I had it right. Yeah, it's been one of those days, for sure, for sure. Hello, Candace. You know, it's crazy out there, everyone. It's crazy. It's, we're in crazy town. Wellness camp. All right. Fair enough, fair enough. Miss Betharoni, hello. Charles, good to see you. You've been sick. Oh no. I think I'm gonna need to. Oh no. Well, you know, in some cultures they say, and I won't name the country, Russia. They say if you have vodka with pepper in it, apparently that's supposed to be helpful. But I'm not sure. That's a. Oh my gosh, that's just what they say. So. Oh my gosh, of course, explain the craziness, the best that we can, do, which, because there's a lot. Hello, Hitch, welcome in. Oh, Willie B, hello. Cobra, are you new? Are you a G.I. Joe? I miss G.I. Joe, everybody. Seriously, I'm not gonna lie to you, I miss G.I. Joe. I mean, that was good stuff. I'm talking about the cartoon. I'm not talking about the movies. I've not seen the movies. I'm talking about the cartoons. That was just good entertainment right there. Whiskey with honey. All right. That makes sense. Terry, hello. Good to see you. Interview tomorrow. Oh my gosh. Fingers crossed. I hope it works out. Hello, Jamie. Oh my gosh. I'll be crossing my fingers for you. Cocoa Latte, hello. BC, welcome. Marge's office again. It's a reminder. Oh my gosh. BC, stop trying to take over the world. Yeah, exactly, Kaya. Yeah, I mean, you know. Yeah, the G.I. Joe cartoons. I swear, everybody, I swear. So again, as I'm just waiting for everyone to get their notifications here. So G.I. Joe, it was a cartoon. And I swear to you, everyone, at the very end, they always gave a tip. So they gave a tip on, like, if this happens to you, do this, like stop, drop, and roll. And I remember at the end of one of them, it was like a tip, if you feel like you're drowning, how to tread water. It was just like a, you know, if you feel like you are about to drown, do this. And then, you know, anyway, so I remember thinking, oh, okay, well, that's interesting because I don't know how to swim. And when I was in the hotel, I was in a hotel swimming pool and I almost drowned. I know. But I almost drowned. And so the only thing flashing through my mind was not like, well, this is it, life's over. It was that cartoon. Like, your water treading doesn't work. This was not true at all. gonna sue somebody. So I'm not sure that the tips were accurate, but it was a fun show to watch at least. We had a good time watching the show. The cartoon. See out of the pool. Oh, I know, yeah. Live and learn, everybody. Live and learn. We learn more from our mistakes than anything else. So, oh my gosh. Yeah. I mean, G.I. Joe, you gotta take. There's good and there's bad with G.I. Joe. Don't get me wrong. I definitely acknowledge there's some problems with it, but to hang out, yes, thank you. Yeah, I'm glad. Bruce Wayne's mother. Hopefully, Bruce again is doing well tonight. Busy man, I'm assuming. But yeah, it's it comes and goes. I've been having some nice big windows where I'm able to get some things done, so I'm always happy about that. The hotel pools are dangerous. Oh, I know. It's. But I swear, I mean, I think there was like this term, like knowing's half the battle. And I just, for some reason, like if you had quicksand, you know how to get out of quicksand, or land a plane, whatever it is. And I just distinctly remember that drowning one. It's like, this doesn't work. This is false information. Oh my gosh. All right. Well, I probably said more than I should. Welcome in, everybody. Welcome. I think as things get crazier, I too may become crazier as time goes on. So tonight, I have an order that came out of the DC courts, and I think it's a pretty good order. I think it's a good memo. Back door's frozen. Shut. Oh, I know. What would G.I. Joe do? Ask a question. I don't know. G.I. Joe might just, use the wrong weapon. If you ever drowning situation, clothes weighing you down, remove them because it can save. See, the thing is, though, I didn't have, I didn't have enough recognition in the moment because I was panicking so bad that I don't even think I knew I was wearing clothes, and I was, obviously, but that was beyond anything I was able to do. The only thing I was thinking about was G.I. Joe. It was not helpful. Right, exactly, maybe Bet. Exactly, right? You know what I'm talking about. Come on, everybody knows that cartoon, right? Oh, my goodness gracious. Right, I mean, Jennifer, that's what I'm saying. Who needs to know about quicksand? I need to know if I, fill out my tax form wrong. Like, what do you do then? This is what you do when you fill out your tax form incorrectly and send it in by accident. Like, that's what I needed. I didn't need quicksand. Oh my gosh, I'm goofy tonight, everybody. I'm in Goofy Town. Oh my gosh, I think we all just get to a point where we just tip. I'm definitely, I'm tipping a little bit. WD-40, oh my goodness. Yes, did you see Trump in the King Post? I did. And, he has himself called all kinds of things. And so that's what I think about. Like, he wants to be called, like, the boss or the Don or the Mr. Toad. I mean, whatever. He's got all kinds of names. So, of course, we can't normalize it. We got to call him out on it. But also, we have to, know that he's a weirdo. There's some weirdos out there. Oh my gosh, there's a lot of weirdos. Yes. Post about it. That's what I base my. Yes. Everything that's coming out today is crazy. It is. It's bonkers. We're definitely in bonkers land. I call him names too. I know it. No, I don't. I call him really Velveeta Voldemort. Oh, that's so mean. I love Velveeta. Come on now. We're in the Kool-Aid land. Oh my gosh, that's so funny. All right. So let's dive in, everyone. And please forgive my goofiness tonight. It's just one of those days. And I do know, by the way, that Hawk and Falcon are live over on their YouTube. So I'm not going to be on for too long tonight, everyone. But feel free to pop over there and say howdy to everybody. for, you know, whatever. It's not going to hurt my feelings. That's a lot of fun. They do a fun live on Wednesdays. I hadn't planned to do another live today. I was live on TikTok this morning going through the Judge Chutkin order where she had said your request for a restraining order is too broad. You need to narrow it down if you really want to get one. I went through that this morning, and tonight I thought, well, let's take a look at another restraining order here. Let's kind of keep it in the, oh, thanks, Pablo, I appreciate that. Let's kind of keep it going because we're going to be learning a lot about restraining orders here, like a lot. So I had shown, I put over on, and it should be posted here too, where I went through my closet, where I've listed out the cases. I've added another 20 cases to it, and I still have more. There were more filed even today. And I just want to remind everybody, with as manic as things are here, right? We're feeling so overwhelmed. Take a minute and just note that we've got the same people being sued. We have Mr. Trump is named on almost all of these lawsuits. So we'll just use the number 80, all right? We've got 80 lawsuits filed in less than 100 days. And Mr. Trump is named, and the Secretary of Treasury is named, and all of these other people here, even this one, we've got Deputy Assistant to the President, Director of the White House Presidential Personnel Office. All of these people are being named over and over and over again. So although we are overwhelmed, they too are also being just absolutely slammed with all of these lawsuits and their attorneys. So the Department of Justice that's having to fight all of these lawsuits, they're like, do you even have enough attorneys for this? So they're also getting slammed. So it's not just us, and I just want to kind of remind everybody of that. They're having to read this. They're having to look through because they're the ones actually getting sued, and rightfully so. So each time something gets filed, they are served notice, and they have to assign someone to it, and you know, figure out what's next, because every single lawsuit will take its own path, its own journey, and we're in multiple jurisdictions all over the place. We've got most of them in DC, which I suppose is helpful, but a lot of them are all over the place. So let us not forget that by doing what they're doing, they are also getting sued, and they are also have to start prepping all of their cases and making their constitutional arguments. So just to remind everybody of that. Yes, Just Security is a great place. That's where I like to get, I like to pull up their litigation tracker. They do an amazing job over at Just Security. When I want something more specific, I go to the Democracy Docket because they, oh my gosh, their explanations are really, really good. Sometimes I think their explanations are a little bit over people's heads. So you know, I try to come in and cover ground for everybody on to be able to kind of understand what I'm saying. Sometimes it's too simple, and I get that, but also I think it's important that every single person has some idea of what we're talking about here. But I'm telling you, Democracy Docket recently hitting it out of the park. They do great work. They have YouTube. I'm not sure if they are on the TikTok or not. I've just not been hanging out there enough recently to know, but they do great, great work. So, you know, feel free to hop in there. But this is where I'm tracking, and, you know, again, there's just a whole bunch more cases. I just add the new cases to the back of the packet, and then I go and put them up on my door. All right. I need them to calm down, though, because I only have 2 doors. I only have 2 giant doors. Then we're going to have to move to a wall. My husband walked by. He walked by yesterday, and he's like, are these the mad scribblings of a mad woman? I was like, maybe. Perhaps. Not on TikTok yet. Okay, that's good to know. That's good to know. So YouTube is the place for that. But they do great work if you're interested. And I'm pulling these cases up. What I am so happy about is that we've got case numbers here. It's easy for me to pull the case number up and then look at the latest order. So that's what I've done here. This case has to do with Ms. Harris. And Ms. Harris had been removed from her position here. And just to kind of take you through for a minute, just a couple paragraphs so that you know what this case is about. The Merit Systems Protection Board is an independent federal agency, so it's not a political agency. Plaintiff has been a member of the Merit System since June 1st of 2022, following her nomination by the president and confirmed by the Senate. She's entitled to continue to serve as a member of this board for the remainder of her term until March 1st of 2028. So she was appointed to this position, all right? And she is supposed to be in that position until 28, may be removed by the president only for inefficiency, neglect of duty, or malfeasance in office. So they have to have justification. Again, Mr. Trump seems to be treating, and the Musk fella seem to be treating these positions like they are at will. And that's just not how it is with our federal employees. They're not at-will employees for a reason, because Congress made it so that they aren't, and we elected Congress. So, that's just how it is. But he's like, just get out, and that's not appropriate. You're going to get into trouble for that. So 3 reasons here. Here, February 10th, Trump disregarded that clear statutory language, and in one sentence email, which of course is rude, purported to terminate Ms. Harris. That email made no attempt to comply with the statutes for cause removal protection. It simply stated, on behalf of President Donald J. Trump, I'm writing to inform you that your position on the Merit Systems Protection Board is terminated effective immediately. So that's horrendous. And then they go through and explain he had no reason. He had no rationale. They're just cutting for the sake of cutting. What they're trying to get to, trying to save money in the budget stuff, as I'm sure you can all do your research. But if you crunch these numbers, the people and things that they're eliminating are giving pennies, literally pennies of savings. So this is where you think to yourself, I'm going to buy a brand new Rolls-Royce car, and it's going to be amazing. I'm going to spend all this money on it. And in order to make sure it fits in my budget, I'm going to only spend $10 a week on groceries. Like, what are you doing? That's kind of what's happening here, is that we've got this huge amount of money, yes, for tax cuts and various other things, incentives for companies to do business here. Like, oh my goodness gracious, incentives. So by doing this, and then you're cutting those fundamental things that you need in order to survive, which are these positions created by Congress, appointed and approved by the Senate, and then just dismissed outright. So, yeah, that's a lot going on. Hey, by the way, can everybody see my document here, or do I need to get a little closer? Can I get a little bit closer? It looks a little far away. 2-minute noodles. Oh my goodness. Yeah, how is the visual? Do we need a little bit closer? By the way, I lost my thumbnails earlier. I tell you, this cold weather and glue. Okay, fine. It's fine it's close enough. Okay. Older folks, you could zoom in a bit. All right, fair enough, John. Here we go. Hope you had a good birthday, by the way. John, there we are. All right, see, I'm a bit of an older folk myself, and that's why I was like, wait, can we see it? So what has happened then in this particular case with Miss Harris? I'm trying to get back into it here. I'm easily distracted. Oh my gosh, even closer. That might be too close. This might be the best I can do. What has happened then is, of course, she has sued and said, look, I'm supposed to be here until 2028, and that's what the Senate said. And so they're asking for a restraining order, meaning that she needs to go and be put back in her position. And that's what the restraining order is for. They requested that. Now, the preliminary injunction is something that will come later. But here we have a restraining order, and the judge has granted it, spoiler, out of D.C. But something that's so important here is we have so many cases. I'd say 3/4 of our cases, 2/3, 3/4 of our cases have some kind of restraining order, preliminary injunction element to it. And in the federal court, there are certain elements that have to be met in order for that preliminary injunction restraining order to be granted. So this judge here goes through what those elements are and how this case fits in those elements, and then granting it. I think it's really important to look at the analysis here, because we're going to be seeing that quite a bit. Right. So let me put my sticky note up here. We've got Harris v. Bessent. So I really think it's important. We talked already this morning a little bit about the Judge Chutkin restraining order situation, but then we've got another one where it was approved, and I thought this would be helpful to kind of compare and contrast the two different requests here. This is a fired employee, fired person, and restraining order approved. Here we go. Restraining order against government. Right. So far, everyone, too, by the way, I have, again, on my door where I have all these cases set out. There are 2 cases in which the administration is not fully complying. So those 2 cases I have put in their own special category so we can watch and see what happens. They are set to the side. 2 of them have to do with the federal funds that have been frozen, where the court has put a restraining order injunction in place, and that's not being complied with. And so the court now has said you need to comply or you're going to be in contempt of court. So those 2 cases I have set to the side, and I'm watching those very closely because I'm not exactly sure what's going to happen. We've got lots of different options, and I'm not sure which one the court will choose. So we will find that out as we go through that. Him and Elon are fighting. There's a lot. And what's so interesting is that I think Elon's really kind of working the situation. And he's saying, well, they want us to fight. They want us to not like each other. And then, you know, Trump's like, I'm tired. I want to play golf. Just take care of business. So we've got that situation at hand. I think when Trump finally has his ego harmed enough, I think he will finally at that point be like, look, we got to break up. We'll see. Because he's not afraid to break up with like money, businesses, ethics. He'll break up with anything. So, oh my gosh. Exactly. Oh, right. Playing him like a fiddle. Absolutely right. As is Putin. So, here we go, everyone. This is the order again. So this is our restraining order granted against the government for this case involving Ms. Harris. Here's our case number up here, if you're interested. This is document number 9. It was filed just yesterday, and I will go through and, look at this course analysis, and we can kind of use this opinion when we start going through the other cases, because we even have one restraining order that's been appealed all the way up to the U.S. Supreme Court, and there's a request for a writ of certiorari that is now on file, and it has to do with a restraining order. So again, having this analysis I think is really helpful because we're kind of setting everything up for the other cases that are in line. Right. Makes me feel better. Oh, Hitch, that's so sweet. No problem. Yeah, of course. I mean, you gotta laugh, right? We all have to laugh. It's important. Don't lose the humor, everyone. All right, here we go. Let's dive in. Memorandum and opinion granting plaintiff's motion for temporary restraining order. Number 1, introduction. So this will set out what we're talking about here. Plaintiff Kathy Harris was appointed to the Merit Systems Protection Board, or MSPB, on June 1st of 2022. To a term set to expire March 1st of 2028, federal law states that members of the Merit Systems Protection Board may be removed from office only for inefficiency, neglect of duty, or malfeasance in office. Again, this is the court order that we're looking at here. On February 10th, Trump informed Harris her position on the board was terminated effective immediately, but provided no reason for Harris's termination. The following day, Harris filed this lawsuit against Trump and several other federal officials, claiming that her termination violated federal law. She moves for a temporary restraining order, declaring her removal from office to be unlawful, declaring that she remains a member of the board, and enjoining defendants from treating her as having been removed. So this is kind of the 1-2 punch. Not only is she supposed to be able to go back to her job, but other people are not allowed to treat her like she doesn't have that job. So I think this was really important. For the following reasons, the court grants that motion while the parties fully brief a motion for a preliminary injunction. So again, this is something, a restraining order is something that's supposed to be very temporary, and the court's acknowledging that. This isn't something that's forever at this point. It's temporary until we can get into kind of the meat and potatoes of the case. Here's our background. A, statutory background. Again, our statutes are written by Congress, right? So you gotta follow the rules. Congress created the Merit Systems Protection Board as a component of the Civil Service Reform Act of 1978, which establishes a framework for evaluating personnel actions taken against federal employees. So there's a whole law telling people how to take actions. And for me, I keep thinking, like, why didn't you just follow the law, and then you wouldn't get and they wouldn't be getting sued. Like, it's not that hard. Congress's findings and statement of purpose indicate that it is the policy of the United States that to provide the people of the United States with a competent, honest, and productive federal workforce. Federal personnel management should be implemented consistent with merit system principles. And then we've got federal law set out here. Those merit system principles include, among other things, recruitment from qualified individuals, where selection and advancement is determined solely on the basis of relative ability, knowledge, and skills after fair and open competition, which assures that all receive equal opportunity. So, unlike what Mr. Trump and his administration think, there is actually not a DEI requirement for quotas. It's based on skills. That's a different life. Moving forward, Congress additionally instructed that employees should be protected against arbitrary action, personal favoritism, or coercion for partisan political purposes. And that makes sense, as well as against reprisal for the lawful disclosure of information, which the employees reasonably believe evidences, among other things, violations of law, gross waste of funds, and abuse of authority, or substantial and specific dangers to public health or safety. So here's the rules. It's made that way by Congress. The CSRA established the MSPB as an independent agency consisting of 3 members and charged it with protecting the merit system principles and adjudicating conflicts between federal workers and their employing agencies. You can kind of see why they'd want to get rid of everybody here. Get rid of the hurdles, get them out of the way so we don't have to deal with them, right? Establishing prohibited personnel practices such as the employment discrimination, unlawful political activities, and any other violations of law within the federal civil service. The board reviews federal employee appeals of adverse actions which are appealable to the board under any law, rule, or regulation, including those related to removal or suspension for periods greater than 14 days. It may order federal agencies and employees to comply with its decisions and conduct studies relating to the civil service for the president and Congress. Under federal law, the board also reviews rules and regulations of the Office of Personnel Management. This is a really big piece because this personnel management, is huge in P25. So Project 2025 essentially went in and said, we need to take over all the personnel and put our own people in. Even if it's not supposed to be political, it doesn't matter. We need to put our own people in. Wink, wink. So that was a huge mission of that. So final decisions are generally subject to judicial review, which is where we are right now. Members of the board are appointed by the president by and with the advice and consent of the Senate, and not more than 2 of the members may be adherents of the same political party. So we need to have a wide, broad group of people. Members of the board are appointed to 7-year terms that may be extended by up to 1 year if a successor has not yet been appointed, which shows also you can't just get rid of someone. You need to have a successor in place, in line, before you fire somebody, before they leave. So this is a huge point under the law. Like, not only is she supposed to be serving 7 years, but she's not supposed to be replaced until someone's brought in that can replace her. That's, how important her job is here. Under the law, any member may be removed by the president only for inefficiency, neglect of duty, or malfeasance in office. Again, we're at 5 United States Code, Section 1202, sub D. Here's our factual background in here. Well, she was appointed in 2022. She was supposed to be there till 2028, so she had 3 more years to go. And I mean, that's like half, right? So she had only served about half her term. Factual background. President Joseph R. Biden initially nominated Harris to be a member of the board on June 24th of 2021 and renominated her again on January 4th of 2022. The Senate confirmed Harris in May of 2022. She was sworn in on June 1st of 2022. Her term expires March 1st of 2028. The Senate later confirmed Harris as chairman. So that's important. And she was sworn in as the chairman on March 14th. Oh my gosh, these people that just don't live in reality come in and are like, all right, everybody's fired. It's like, this isn't a TV show, dude. There's like protocols that have to be followed. On February 10th, Harris received this email from Trent Morse, Deputy Assistant to the President and Deputy Director of the White House Presidential Personnel Office, which stated in its entirety, quote, on behalf of President Donald J. Trump, I'm writing to inform you that your position on the Merit Systems Protection Board is terminated, effective immediately. Thank you for your service. Again, this is just horrendous. The communication does not explain the basis for Harris's termination, of which you need to have one of three requirements here. Harris filed the lawsuit on February 11th of 2025, claiming her firing was ultra-vire, unconstitutional, and a violation of the Administrative Procedure Act. She seeks relief under the Declaratory Judgment Act, issuance of a writ of mandamus or mandibus. That means writ of mandamus or mandibus. This is going to be something that you're going to hear a lot of, everyone. So I want to highlight this for a minute. This writ of mandibus or mandamus is what the court uses to order another person in the government to do something. So the Supreme Court can order the United States president to do something, and they do it through an order of a writ of mandamus. All right, so know this term. This is forcing a person, a government person, to do something. That is what this is here, and equitable relief. So she's saying, we want judgment. We need you to force them to allow me to have my position, and equitable relief. Harris additionally filed a motion for a temporary restraining order, which defendants oppose here. And on February 13th, the court held a hearing on that restraining order. Next, we have the legal standard, which you're going to hear this standard over and over and over again, everyone. The purpose of a temporary restraining order is to preserve the status quo for a limited period of time until the court has the opportunity to pass on the merits of the demand for a preliminary injunction. So that's exactly what's happening here. We put in a restraining order so that everything stops until we can take a look at this preliminary injunction. So restraining order first, then injunction comes up. And I'm using those terms interchangeably because all of these cases are at different points. Some have restraining orders, some are already set for injunction. So I do use them interchangeably. An application of a restraining order is analyzed using the same factors applicable to a request for preliminary injunctive relief. And that's important because they granted her restraining order here in order to get that preliminary injunction filed, that motion. And if she won a restraining order, it's incredibly likely she will win also her preliminary injunctive relief. So this is, again, that foreshadowing piece to keep in mind. Now, preliminary injunction is an extraordinary remedy that may only be awarded upon a clear showing that the movant is entitled to such relief. So it's very high requirements. And then we're citing different case law here. A plaintiff seeking a preliminary injunction must establish, 1, that he's likely to succeed on the merits, 2, that he's likely to suffer irreparable harm in the absence of a preliminary relief, and 3, that the balance of equity tips in his favor, and 4, that an injunction is in the public interest. So again, this preliminary injunction is what they're talking about for the 4th element as opposed to the restraining order here. The last two factors merge when the government is the opposing party. So 3 and 4 are actually just one element because of how it's written up in precedent. Of course, the movement carries the burden of persuading the court that these factors merit preliminary relief. So it's the people asking for it that have to prove it, citing for the case law, and must do so by a clear showing, and that's the level of burden of proof, right? So we have Clear showing versus preponderance of the evidence versus beyond a reasonable doubt. These are all separate different levels of burdens of proof. And so here, the level is a clear showing. That's all they need to show. So pretty low. A preliminary injunction may be granted based on less formal procedures and on less extensive evidence than in a trial on the merits, which of course we know that as well. Next, the analysis. The court concludes that Harris has established a strong likelihood of success on the merits, that irreparable harm is likely to occur in the absence of injunctive relief, and that the public interest weighs in favor of enjoining defendants' actions. Harris has thus carried her burden to establish that a temporary restraining order is warranted here. And it's important to note in the DC case involving Musk with Judge Chutkan, they did not meet their burden. It's the same burden. And she said, you didn't show irreparable harm. And that is why that was denied. So here's A, likelihood of success on the merits. And this, is something to really pay attention to, because they're talking about if once this gets in front of me as a full-blown case, this is what I'm thinking already at this point. Harris argues she's likely to prevail on the merits of her claim based on Supreme Court precedent and the nature of the board's power. So flipping the page, here we're on page 6. Specifically, she argues that the case, Humphrey's executor versus U.S. and its progeny, confirms the constitutionality of the conditions placed on removal of a board member. She has a case that's like just exactly what's happening here. She additionally cites the board's limited authority, quasi-legislative functions, need for independence and accountability to Congress, and the president as reasons for the constitutionality of a member's appointment for a term of years with specific conditions for removal. Defendants argue that the Humphrey's executor does not apply because the board exercises executive power. It may issue orders to federal employees, adjudicate and take final action, and litigate on its own behalf. The court concludes that Harris has demonstrated a likelihood of success on the merits. So, worth noting here, and what we're going to hear over and over and over again is from Trump's people, is they're going to say, well, this is executive power. So if this is just executive power, we're in charge of it because the president's in charge of the executive branch, right? So that's what their argument's going to be. But in this situation, the judge is like, nope. Humphrey's executor appears to dictate the outcome of this case. So when you've got a law that's already in place, that's exactly the same as the case you're dealing with, that's like the best case scenario. The Federal Trade Commission, FTC, comprises 5 members appointed by the president by and with the advice and consent of the Senate, and not more than 3 of the commissioners shall be members of the same political party. Any commissioner may be removed by the president for inefficiency, neglect of duty, or malfeasance in office. The Humphrey executor President Hoover had appointed, in that case, Hoover had appointed William Humphrey as a member of the Federal Trade Commission, which carried a term of 7 years. Less than 2 years later, President Roosevelt terminated Humphrey over differences of political opinions, stating, quote, effective as of this date, you're hereby removed from the office of Commissioner of the Federal Trade Commission. Humphrey died several months later. Oh, that's awful. Oh, that's so sad. Oh, man. I tell you, sometimes Roosevelt, I'm just not sure. I'm not sure about that. But his estate sued to recover back pay on the basis that his removal was unlawful. Whoa, what a great case. This is really a great case. He needs to stay in his lane. Oh, my gosh, perfectly put. That's exactly right. The Supreme Court confirmed that President Roosevelt's termination of Humphrey was indeed unlawful. The court observed that the statute fixes a term of office in accordance with many precedents. The court further explains, the commission is to be nonpartisan, and it must, from the very nature of its duties, act with entire impartiality. It is charged with the enforcement of no policy except the policy of law. Its duties are neither political nor executive, but predominantly quasi-judicial and quasi-legislative. Like the Interstate Commerce Commission, its members are called upon to exercise the trained judgment of a body of experts appointed by law and informed by experience. So there you have it right there. I mean, that's huge. That's a huge finding. The court differentiated FTC members from the postmaster in the Myers case, evaluating statutes saying postmasters shall hold their offices for 4 years unless sooner removed or suspended according to law. A postmaster is an executive officer restricted to the performance of executive functions and is charged with no duty at all related to either the legislative or judicial power. So making that distinction between if you wanted to go after the post office people, that's different because those are all executive situations. But this board that we're talking about is legislative as well as judicial, and that's a different can of worms. The FTC, in contrast, acts in part quasi-legislatively and in part quasi-judicially, rather than exercising traditional executive powers. Again, these traditional executive powers is what Trump's team is trying to say is happening because, you know, he's in charge of the executive branch. We think it plain under the Constitution that illimitable power of removal is not possessed by the president in respect to officers of the character of those just named, the court concluded. So again, this judge here is saying, we've already got a case that sets out you can't do this stuff. 2 decades later, the court considered President Eisenhower's removal of a member of the War Claims Commission, whom President Truman had appointed and the Senate had confirmed in Weiner v. United States, 1958. Congress charged that commission with processing claims of compensating internees, prisoners of war, and religious organizations who suffered personal injury. Personal injury or property damage at the hands of the enemy in connection with World War II. And commissioners' terms were limited by the short duration of the commission's existence. The court reasoned Congress intended to preclude the president from influencing the commission and passing on a particular claim, which meant that the president naturally could not hang the Damocles sword of removal. So this is really unnecessary. If you all are familiar with that, there's a sword that's just hanging by this thin thread, and at any time it can drop, or maybe it won't drop. Will it drop? I don't know. Will it drop? Will it not drop? So that's that reference. Over the commissioners, the court reaffirmed that the president had no such power to remove a member of an adjudicatory body like the War Claims Commission merely because he wanted his own appointees on such commission. And then we have footnote number 1 here. Does the SCOTUS decision in Chevron change that ruling? That's a good question, Chris. So in Chevron, it's not the Chevron case. I mean, it's the Chevron doctrine. In the Chevron doctrine, it says if there is some ambiguity in the law, that the agency can make that determination. And here, we don't have an agency action. We're not dealing with that. We're dealing with the executive, so the president, who has the authority to fire this person, making that decision. It's just in order to fire them, you have to have a reason, one of 3 reasons. So we're in a different place. We're kind of off to the side of the Chevron situation. I wouldn't see that as a factor, and that's my best guess here. Of course, you know, I'm not in front of the U.S. Supreme Court, so... But that's what that whole doctrine was about. The Supreme Court recently recognized, and with the change in the doctrine, what has changed is that it's not up to the agency, it's up to the court, and we are in the court. So this would actually be in compliance with Chevron if it was to be applicable. The Supreme Court recently recognized the constitutionality of this narrow restriction on the president's removal power in SELA Law versus Consumer Financial Protection Bureau in 2020. Humphrey's executor, the court explained, permitted Congress to give for-cause removal protections to a multi-member body of experts balanced along partisan lines that performed legislative and judicial functions and was said not to exercise any executive power. So as I pause here, let's bump down to the footnote here before I forget about it. So there we go. Footnote 1, the court once again considers a multi-member body in Mistretta v. U.S. when passing on the constitutionality of the United States Sentencing Commission, which formally resides in the judiciary. The Sentencing Report Act of 1984 empowered the president to appoint commissioners to the Sentencing Commission, with members subject to removal by the president only for neglect of duty or malfeasance in office or for other good cause shown. And when considering whether an act affords the president undue influence over federal judges who served as commissioners, the court recognized that the president's removal power under the act is limited. Such congressional limitation on the president's removal power, like the removal provisions upheld in the Morrison v. Olson case, which is a huge case, and Humphrey's executor is specifically crafted to prevent the president from exercising coercive influence over independent agencies. And we'll be seeing that cited quite a bit. Next up, here we've got another case law, free enterprise funds. And we're summarizing Humphrey's executor as holding that Congress can, under certain circumstances, create independent agencies run by principal officers appointed by the president, whom the president may not remove at will, but only for good cause. Again, this is the whole thing. You have to have good cause to get rid of a civil servant because of how the laws are written. You can't just do it because, you're like, okay, let's get rid of them. You can't just do that under the law. All right. This case appears to be on all fours with Humphrey's executors. What? Come on, really? The board, the Merit System Board, is a multi-member body of experts that's balanced along partisan lines. The president will therefore likely have the opportunity to shape its leadership and thereby influence its activities. The CSRA envisions that the board is to be nonpartisan, and it must, from the very nature of its duties, act with entire impartiality, citing that Humphrey's executor case. So this case, I think, would be worth pulling and reading through. Yes, tea break, thank you. All right, the CSRA also fixes a term of office. The MSPB's duties are quasi-judicial in that it conducts preliminary adjudication of federal employees' claims, which may then be appealed to the federal circuit. Although the MSPB lacks its own rulemaking authority, Congress intended the agency to aid in its legislative goals by regularly transmitting reports to Congress regarding the board's functions. It is additionally evident that Congress hoped to preclude the president from influencing the board in passing on a particular claim. This precedent is really rock solid, and we love to see that. We love to see the precedent that is absolutely, set in stone here. Although technically nothing's really set in stone, but this precedent is very helpful. The board additionally regulates government activity rather than that of private parties, limiting the risk that its members can represent any special threat to individual liberty, citing the Celia Law case, emphasizing that the board does not regulate or penalize private activity. Instead, the board primarily enforces the merit system principles within the federal government and responds to prohibited personnel practices such as employment discrimination and retaliation against whistleblowers. So this is such a huge deal. When they're trying to eliminate the people overseeing the whistleblowers. And that's not good. That's never good when you're trying to take the power away from the people who look into these cases. This authority is fundamentally narrower than that of the FTC, which regulates private conduct. Citing law here, defining the scope of trade practices regulated by the FTC, empowering the FTC to regulate commerce. And Dellinger versus Bessent, here we've got a per curiam decision. And this case is, that's interesting. This, I believe, is a Pennsylvania case with federal funds that's in the DC Circuit. Per curiam, meaning from the bench, explaining that the Office of Special Counsel is not an agency endowed with the power. Oh, that's my bad. This is not the Pennsylvania case. This is the Special Counsel case where they're doing away with the entire Office of Special Counsel. Not Jack Smith's Special Counsel, it's a different one. But it's not an agency endowed with the power to articulate, implement, or enforce policy that affects a broad swath of the American public or its economy. So these two cases go really hand in hand. The Dellinger case and then the Harris case here are hand in hand because they both are cases where there were terms set out by Congress that have been violated. All right. The board also remains politically accountable to Congress and the president through the appropriations process in a matter inapplicable to independent agencies with their own funding sources. Citing further law here, it's not funded through ordinary appropriations process. Finally, the board's mission and purpose require independence. In enacting the CSRA, Congress exercised its power to regulate the civil service. And they're setting out case law there. Congress and the president are responsible for an efficient public service. So it's hand in hand, everybody. It's not just the president. Come on, man. Take a civics class. It defined certain prohibited personnel practices to include discrimination, loyalty oaths. Hello, we're dealing with that right now. Yikes. Coercion to engage in political activity and retaliation against whistleblowers. Direct political control over the MSPB would have limited effect on the president's implementation of his policy agenda. It would instead neuter the CSRA's statutory scheme by allowing high-ranking government officials to engage in prohibited practices and then pressuring the board into inaction. The board's independence is therefore structurally inseparable from the CSRA itself. And we have footnote number 2. Footnote number 2, furthermore, the board's duties dovetail with U.S. v. Perkins, in which the Supreme Court held that Congress may place some limitations on the removal of inferior officers. So we have a U.S. Supreme Court case here from 1886 saying you can set out requirements of the inferior officers. You can set the requirements for what it takes in order to fire them. And that's out of 1886. I mean, that level of precedent here, again, you put this in front of the U.S. Supreme Court and like, look here, we've got a case from 1886 that says Congress can add these things to it. That's incredibly powerful. So that's something to keep in mind as we go through this. Denying independence to the board would undermine these constitutionally sound limitations on the removal of civil servants. Next, because the board falls within the scope of Humphrey's executor case, Congress has the power to specify the members of the board may serve for a term of years, with the president empowered to remove those members only for inefficiency, neglect of duty, or malfeasance in office. The president did not indicate that any of these reasons drove his decision to terminate Harris. The court thus concludes that Harris has demonstrated she's likely to show her termination as a member of the board and that was unlawful. So the judge is already saying she's probably going to win her case at this point, because look at the precedent, look at the cases, she's probably going to win because this was not appropriate. So let's bump down. We've got footnote number 3 here. We'll bump down. Defendants argue that Harris cannot show entitlement to reinstatement because she's been removed from office. And the president cannot be compelled to retain the services of a principal officer whom the president no longer believes should be entrusted with the exercise of executive power. So again, they're tossing around this idea that the president can just do whatever he wants. Defendants posit that Harris's remedy should be limited to back pay. They don't want to have her in office anymore. Now we've got this case here. Sampson, discussed further below, appears to cut against this conclusion, as the Supreme Court did not wish to be understood as foreclosing injunctive relief in the genuinely extraordinary situation. In addition, the court's job at this stage is to determine whether to issue a temporary restraining order preserving the regime in place before defendants issue the termination order while the issues are fully considered. So they're saying, yeah, this is a big deal. They're saying, we don't want her back. The president's lost faith in her ability to do the job. So, we don't want to put her back in. Meanwhile, the court's saying, hold on, we need to go back to where it was before, and you're going to have to deal with that. That's, what a restraining order in this situation does. So next up is the, circular logic. Oh my gosh. Next up is the irreparable harms. Let's take a look at this. Again, I think these elements in irreparable harm, and then we'll kind of skip to the end here, but the different elements are going to be really important because we're going to use them over and over and over again on all of these cases. Harris asserts she will suffer irreparable harm because absent interim relief, she will be deprived of her statutory right to function as a senior government official. and reciting case law. She additionally contends that the injury will be irreparable because her claim to the board's membership may be frustrated by the appointment of a successor. So that's pretty irreparable, right? If they are going to put somebody else in her position. She also argues that denial of emergency relief and confusion about the status of the board may deprive the plaintiff and the board of the ability to fulfill their mandate to federal employees. Defendants respond that Harris cannot claim irreparable harm as an employee separated from her position. So basically they're saying, oh my gosh, this is so awful, everyone. Let's just highlight this. This is a terrible thing for someone to say. This is such bologna sandwiches here. Defendants are saying, well, you can't suffer harm because you're no longer there. So we kicked you out. You were kicked out. Here's a box. Gather your stuff up. Get out. And because you're not literally in the position anymore, you can have no irreparable harm. That's awful. And if that was to set the rule, we would have some big problems. And everybody would just get rid of everybody immediately, right? Because then they couldn't come back and say there was irreparable harm. That's terrible. Because the board continues to function with a quorum, and because the president's not yet nominated as successor, the court concludes that Harris has established irreparable harm in this case. So the court's like, nope, we're not going to do that. To sustain injunctive relief, the threat of irreparable injury must be likely in the absence of an injunction rather than a mere possibility. The injury must be, yeah, they're awful people, I agree, truly irreparable. Mere injuries, however substantial in terms of money, time, and energy necessarily expended in the absence of an injunction, are not enough. The irreparable harm analysis assumes, without deciding, that the movement has demonstrated a likelihood that the non-movement's conduct violates the law. In addition, a federal employee seeking an injunction requires the government to employ her during the course of litigation. So, that's the law. Must make a showing of irreparable injury sufficient in kind and degree to override the government's traditional autonomy over its internal affairs, which cuts against the availability of preliminary injunctions in government personnel cases, citing case law here. In the Sampson case, Supreme Court considered whether a probationary employee at the General Services Administration could receive a temporary restraining order enjoining her dismissal during an administrative appeal to the Civil Service Commission. The court concluded that, particularly considering the government's prerogative to manage its employees, the loss of wages and reputation that may be remedied through further proceedings fell far short of the type of irreparable injury which is a necessary predicate to the issuance of a temporary injunction in this type of case. The court nonetheless allowed that a district court is not totally without authority to grant interim injunctive relief to a discharged government employee, and that relief may be appropriate in the genuinely extraordinary situation rather than in routine cases. So the court here is saying, dude, this is crazy. This is a crazy situation, and so I'm going to use my own authority that, break the glass in case of an emergency, which is where we're at right now, is what the court's saying. Harris has established that this case represents a genuinely extraordinary situation, meriting injunctive relief for a discharged government employee, unlike the probationary employee in the Sampson case. Harris was appointed chairman of a federal agency and confirmed by the Senate. And we have footnote 4 here, which says defendants cite numerous cases in which the courts have declined to issue injunctive relief based on the deprivation of a unique, singular, or high-level position. None of these cases involved plaintiffs who enjoyed removal protection enacted by Congress and signed into law by the president. Courts have found injunctive relief warranted in such situations. So this court is saying repeatedly that the law said you have to meet 1, 2, or 3. If you don't have 1, 2, or 3 included, then you can't do this situation. All right. The conditions under which the president may end her tenure are made plain by federal statute, supported by 90 years of Supreme Court precedent. That's a lot. 90 is a lot. And then also they're pulling in the other case against Trump for the special counsel situation. Sampson additionally relied on the well-established rule that the government has traditionally been granted the widest latitude in the dispatch of its own internal affairs. Yet, that concern is minimized in the context of an action that at this stage appears to be nakedly illegal, such that the government's range of options is necessarily constrained. Woo! Those are pretty harsh words. Again, some things you don't want to hear from a judge regarding your case. Nakedly illegal. That's not a phrase you want. That's not something you want coming towards you here. Harris cites Berry v. Reagan, which, although vacated as moot under U.S. v. Munsingware, remains instructive here. So they're saying, I'm not using this as precedent to rely on. I'm using this as a way of looking at the situation. In that case, Congress established the Commission on Civil Rights as a temporary bipartisan agency to be composed of 6 members appointed by the President by and with the advice and consent of the Senate. The commissioners were to serve for a fixed term set to expire 60 days after submission of the Commission's final report and recommendations to the President and to Congress. 3 years after their appointments, Reagan notified the commissioners of their terminations, and they sought an injunction. Now, you know things are getting real when Reagan's being brought in, everyone. That's a red flag. Oh my gosh. Naked. Oh my gosh, that's so funny. Willie B, I have to stop reading comments out loud. I need to read them quietly to myself first and then out loud. Oh my goodness gracious. I'm going to get in trouble. Oh my gosh. Oh my gosh, that's cracking me up. It's cracking me up here, everyone. All right, the Berry Court proceeded through analysis remarkably similar to that here. The court considered whether the Civil Rights Act of 1957 contained a congressional intent to protect the commissioner's independence under Humphrey's executor. After concluding Congress intended the commissioners to serve for the full life of the commission, the court moved on to consider irreparable harm. The court then looked to Sampson to determine if the commissioner's injuries override the factors mitigating against the issuance of preliminary relief in government personnel actions. The court concluded that the injury was irreparable because denial of preliminary relief would have an obviously disruptive effect on the commission's final activities. Moreover, the court continued, it's not clear that the president has the power to remove commissioners at his discretion and that he should be given the widest latitude to exercise his authority. In addition, the commissioners did not have administrative, statutory, or other relief that's readily available to many federal employees. And we have footnote 5 here. The court then granted the injunction. So let's bump down to footnote 5 here, where it says the parties do not discuss what administrative relief may be available to Harris here. So the court does not consider the issue. So the next piece, again, has to do with another case where the Trump administration is being sued. So we'll kind of walk through that to give us a little insight into that case. This is another huge one to watch. This is the one, wait, hold on. Is Dillinger the one that's going up to the U.S. Supreme? Okay, I'm getting them mixed up. No, it's the Pennsylvania case going up to the U.S. Supreme Court, not this one. Sorry. Oh my gosh. This one, though, I have a feeling will be going up eventually. I'm getting my cases mixed up. It's either Dillinger or Pennsylvania. I think it's Pennsylvania. One judge in this circuit recently issued a temporary restraining order under similar circumstances. So this, again, is where they are suing Trump for removing them from their position. In that case, the president terminated special counsel Hampton Dillinger, who was appointed to a 5-year term to the Independent Office of Special Counsel and may be removed by the president only for inefficiency, neglect of duty, or malfeasance in office. The court concluded that these for-cause removal conditions were likely constitutional. Analyzing the irreparable harm, the court also turned to Sampson and Berry, determining that Dillinger was appointed for a fixed term and that he has a statutory mission that his removal has rendered him, rendered him unable to fulfill. The loss of the ability to do what Congress specifically directed him to do cannot be remediated with anything other than equitable relief. At the motion hearing in this case, defendants argued that Dillinger is incorrect, in part because the court there conflated the notion of an agency's statutory right to function with what they say is essentially an employment action. But Berry, Dillinger, Humphrey's executor, and Weiner, taken together, make clear that these cases represent far more than grievances over back pay and routine personnel issues. Like the plaintiffs in Berry and Dillinger, Harris was appointed and confirmed as a member of an agency charged with acting with a degree of independence from the president. By vindicating their rights to occupy these offices, the plaintiffs act as much in their own interests as those of their agencies. You may have footnote 6 here. Indeed, Harris stands before this court in her personal and official capacities here. The Supreme Court in Humphrey's executor and Weiner similarly viewed the plaintiffs before them as vindicating the independence of their agencies and discussed at length the nature of the president's power over those agencies rather than the narrow issue of unpaid salaries. So they're really clarifying this situation. They're saying, look, this isn't just a personnel issue. This is a fundamental piece of separation of powers, right? Because of the job of this board and how they are put into positions and the law that created it. This, we can't just look at this as, oh, well, it's just someone who's working there. It's more than that. And we've got, again, Humphrey's executor discussing the relative authorities of Congress and the president over independent agencies. We're going to hear this argument over and over and over again, everyone. The plaintiffs in these cases are not low-ranking staff members at those agencies either. Dillinger was appointed to lead the Office of Special Counsel, and Harris was appointed as one of 3 members of the MSPB. Striking at the independence of these officials accrues harm to their offices as well. So these are huge, important positions that, this has to get sorted out and are supposed to be independent from the president. And why? Because of this very thing. With this in mind, the irreparable harm in this case becomes clear. Were the president able to displace independent agency heads from their positions for the length of litigation such as this, those officials' independence would shatter. Simply put, Congress reasonably concluded that the board cannot serve as an independent protector of the merit system if members are subject at all times to removal without cause by the president. Allowing Ms. Harris's illegal termination to stand, even for a short period, would violate the bipartisan independent nature of the board. Next, even if this court were to direct Harris's reinstatement after resolving the merits of her case, a process that can take some time, the board's congressionally mandated independence would be permanently marred by the threat of renewed removal and delayed reinstatement while litigation proceeds. So the damage would be just extensive. Harris would re-enter the position as the chairman of the board, who had just been removed from her role for a significant length of time. And the Democles, I'm going to say that name wrong every time, sort of removal by the president. So again, it's just this idea that we could have a problem at any time. And that would hang over her and her colleagues. This harm would accrue in the absence of a temporary restraining order, and the passage of time would both cause this damage and preclude a remedy. If there ever were an extraordinary case meriting injunctive relief for a government employee, this would be it. And that's a very powerful statement by a judge. They're saying if there was a time for us to follow the law, it is this case. So that's incredibly powerful. So let's fast forward just a little bit here. We've almost made it all the way through, but we can kind of skip a little bit more of the ongoing harm. But I do want to go through the argument that the defendants are saying, well, we've already kicked her out, so she doesn't have any cause here. She doesn't have any irreparable harm. So I'll go through those couple of paragraphs and then we'll move to the conclusion. Democles. Really? Democles. Man, I tell you, my pronunciation, it's not the best. All right, it's just not. Furthermore, defendants contend that because Harris has been removed from her office and seeks to return, she can suffer no injury in her capacity as a member of the board. To me, this is absolutely ridiculous argument. This is just fundamentally wrong, this argument. And I almost would say this is a bad faith argument. So attorneys, if we don't put in proper language, or if we don't, like Hercules, oh, thank you. Oh, I appreciate that. Okay. If we make an argument that we know is stupid, we make it in bad faith, we can get ethical challenges to us. And actually, if it's pled out in any of the pleadings here that it was done in bad faith and that was actually proven, then they could be sanctioned, or she could actually receive a higher award from that. So I'm just putting that out there. This is just ridiculous. And seeks to return, she can suffer no injury in her capacity, arguing that Harris seeks judicial reinstatement to a principal office, comparing Harris's situation to those of government employees lacking tenure protections. Again, like, there are some people you just can't fire. This puts the cart before the horse, first assuming that the president lacked the power to terminate Harris without cause. Then she rightfully remains a Senate-confirmed member of the board. The Humphreys case, holding that removal power does not extend to an office such as that here involved. Defendants thus conflate wrongful termination with the lack of power to effectuate termination, at least without cause. Second, this position fails to recognize that any later reinstatement of Harris would not restore the state of affairs that existed prior to her purported termination, given that she would no longer serve as a member of a truly independent agency. Whoa, that's really... So that's really, that's another big one here. So the court's saying she wouldn't even be able to do her job because the goal or the mission set out by Congress of having an independent agency would not be independent anymore. So that was a big one. That's a big hit. It's sounding like Mr. Trump's administration will lose. We never know, but there you go. Again, we're just going through the defendant's argument here. Defendants contend that Harris cites no injury of any kind that the Supreme Court has recognized as irreparable in this context. They aver that court after court in this circuit and others has concluded that a loss of employment does not constitute irreparable harm. Indeed, it is well settled that economic loss does not, in and of itself, constitute irreparable harm. And again, the fact that they think this is only a loss of employment, not that there are bigger issues at play, is ridiculous. Yet courts often reach this conclusion based on the notion that wrongfully discharged employees may be entitled to back pay. Here, they're going through case law. This is not the issue in the case, which is Mr. Trump's problem. He doesn't know what the issues are. He doesn't plead the issues out properly. Harris does not seek compensatory damages, but rather complains of injuries arising from her inability to occupy a position at the independent agency following her presidential appointment and Senate confirmation. So the president put her in this job. She was confirmed by the Senate. So it's the job. It's not the money. It's the job itself. Defendants additionally cite English v. Trump for the notion that any such harm to plaintiff coming solely from her not functioning as a member of the board can be remediated in the ordinary course of the case. In English, the board director resigned. He appointed his deputy to take his place, and an apparent conflict arose between the two statutes governing succession of the agency. One provision, the Dodd-Frank Act, stated that the board deputy director would serve as acting director in the absence or unavailability of the director. The Federal Vacancy Reform Act, however, also grants the president the power to appoint acting officers, either from within an agency or from a different agency, if the official is state confirmed. The English court, the English case, determined that the two statutes could be read to avoid conflict. Now, let me skip down here. Again, we're going through the English doctrine, and I think we can go ahead and move past that because we've got the court already saying here that this kind of an argument is failing. So let's move over to the balance of the equities and public interest. So here's our last piece, and then we'll have the conclusion from the court. Harris argues that the balance of the equities and public interest weigh in her favor because the government's recent flurry of personnel actions has led to uncertainty that requires stability at the board. Defendants respond that the public interest counsels against injunctive relief, which would intrude into the president's authority to exercise all of the executive power of the United States. I wonder who the attorneys are that are trying to argue this crap. I'm just curious. I'm wondering, because it's all, these are all government attorneys in here. Talk about not having to pay legal expenses. All of the money that they're trying to save by firing these people, they're spending on lawyers defending all of these cases. And that's sad. That's a sad moment. Given the federal law limits the conditions under which Harris's tenure may be terminated, Supreme Court precedent supports the constitutionality of those conditions, and defendants do not argue that those conditions were met here. I mean, come on. The court finds that it's in the public interest to issue injunctive relief. There's a substantial public interest in having governmental agencies abide by federal laws, oh my gosh, that govern their existence and operations. This should not have to be said. This should not have to be told to the President of the United States. We shouldn't have to tell you that you have to follow the law. Oh, this makes me so frustrated. So, too, is there substantial public interest in the protections for removal Congress has given to certain members of independent agencies. Furthermore, the government cannot suffer harm from an injunction that merely ends an unlawful practice or reads a statute as required. So we have to also watch out right now, because I know there are executive orders that he's trying to put through, basically saying that he's giving himself the authority to override these statutes. I'm like, that's also not how that works. So here's conclusion. For the foregoing reasons, the plaintiff's motion for a temporary restraining order is granted, and it is further ordered that from the date of entry of this court's order until the court rules on a preliminary injunction, plaintiff Kathy A. Harris shall continue to serve as the chairman of the board. Defendants here, this Bessent, Morse, and Gorge, and Kerner, and Vout are enjoined from removing Harris from her office or in any way treating her as having been removed. So she should be able to go into the office and start doing her job. And if they prohibit her from doing that, they're in violation of the order. Denying or obstructing her access to any of the benefits or resources of her office, placing a replacement in her position, or otherwise recognizing any other person as a member of the board in Harris's position, pending further order of the courts. So this is pretty, pretty strict. Like, don't screw around with her, man. We got to get this sorted out in court. It's further ordered, Harris shall file any motion for preliminary injunction on or before February 23rd. So, of course, she's going to need to file that. Defendant shall file any opposition on or before February 28th. Harris shall file any reply on or before March 2nd. It's further ordered, the party shall appear for a hearing on the motion for preliminary injunction. If such a motion is filed on March 3rd of 2025 at 2 p.m., and that the court will rule on the preliminary injunction as soon as possible thereafter. And it's further ordered that the parties shall meet, confer, and submit a joint status report on or before February 19th. And they have actually already submitted that. So that is on the docket already, if you want to take a look at that. Informing the court of their respective positions on whether consideration of the motion for a preliminary injunction should be consolidated with the merits pursuant to Federal Rule of Civil Procedure 65A2. An order consistent with this memorandum opinion, separately and contemporaneously issued and signed by Judge Rudolph Contreras here. So, yikes, everyone. We're going to be hearing the same arguments here quite a bit. This is just going to be repeated over and over and over and over again for all of these cases that have pulled people who were appointed to that position. These arguments are completely valid. So we love the precedent. That's what we love. We love that. We love the federal statutes that clearly set the language out and the rules. We've got an 1800s case saying that those rules are okay. So we love all of those things. We love everything here. The judge also knocked out the defendant's argument saying, well, she's gone, so she's not going to have any harm. The judge is like, nope, you need to put her back and don't block her ability to do her job or her ability to go back into her position. So those are all great things here. Those are all very good things. So there is that, everyone. This is, again, the Harris versus Bessent case. I will be keeping our eye on this one. We have several other cases that we're watching here. Of course, we've got one case that's already up on a cert request to the U.S. Supreme Court. In my opinion, they'll probably deny cert, I think, in my opinion. Restraining orders are so temporary. By the time the Supreme Court heard briefs argued, set times and all of those things, like the temporary restraining order would be over. It would have expired by the time the Supreme Court even gets it docketed. So it doesn't make any sense for a TRO to actually be in front of the Supreme Court unless there's a crazy, weird situation, of which we have, but I'm not sure that it's that crazy. We've had crazier. I was goons outside her door. That's the thing, Achilles, is that's what the judge is saying here. By doing that, you're going to be in violation of the court order. And in this situation, there's no immunity. There's no immunity for goons to be going against a federal court order. They're standing outside preventing her from getting into the office. They are violating a court order. There's no immunity, and they can be arrested and put into jail. Everyone needs to be going to jail. So, I kid. So, thank you, everybody, for coming. Thanks for reading it. Absolutely. I'm going to do my best here to keep everybody on top of these cases as best I can. I'm thinking about doing kind of a summary of my closet door cases each day, like what cases have been added, which cases have been moved. So I will try to do that as best as I can. Again, this case, the reason why I wanted to go over it tonight, everyone, is because these arguments for restraining orders, we're going to be seeing them over and over and over again. So by having this basis for your foundation, you'll have some idea of what we're talking about when the judges are asking for briefing, when they're asking for hearings, those kinds of things. It's because they're needing to sort through these factors that are required for this preliminary restraining order, and then those injunctions can be requested as well. And again, foreshadowing, the judge here saying, yeah, you're probably going to win your case. This is the judge that they're going to be arguing to. So he's already like, yeah, you got it. You got a good case. Your case is solid. Looks like you're going to win it. Do you believe we're in a constitutional crisis right now? That, I guess I feel like we're always in a constitutional crisis. I mean, as an attorney, we file about violations of constitutional law constantly, like every day we file it. I think just a crisis itself, we're in a constitutional conundrum, maybe is a better way of putting it. I will be hesitant. I will be worried if there comes a point when the federal court order is being clearly acknowledged and refused to comply with it. So that's when I think we're at a crisis point. If Mr. Trump comes out and says, yeah, I see your order, court, but we're not doing it, that's when we're going to be in a huge crisis. Now, Lincoln had the situation before when he suspended habeas corpus. We were in a civil war, right? And then we had the other guy, Johnson. Is it Johnson or Jackson? I screw his name up because I don't like him very much. We were also in that weird situation, a civil war, and that president was, crappy. A Sharknado. So funny. So yeah, he was his own. He had problems, that fella did anyway. So we're in a different territory here. It's not going to go completely that way. That just gives us some insight. But if Mr. Trump comes in and says, nope, I'm not gonna follow the court order, just says that, affirmatively asserts that, now we're in a crisis situation. That's really when we're gonna have trouble. So look for that. With the freeze of the funds, we're working through that, Navy vet, because we have, first, to answer your point, yes, Second, the court came back and said, dude, you're not following the order, which can happen. Usually we wouldn't have that happen by someone at this level of authority, but whatever. And they're saying you need to get this sorted out, and here's your time frame. So if that time frame comes to an end and they haven't sorted it out, now we're going to have some trouble. So we're going to have to take a look at that. They've quoted Andrew Jackson. Yeah, I mean, of course. Yeah, sorry, the president. The president. No, not the speaker. He's just the little man with glasses. Yeah, no, Andrew Jackson. Sorry about that. Yep. What happens if he refuses to listen? Well, then we're going to have some mandamus. We're going to have, in my opinion, we would have a writ of mandamus done by the court, and the court would have to pull him back into compliance. The court can order whomever they need to go for and execute their order. And, there you have it. The court has the power to force a president to do something. They just have to be creative about it. And you might say, well, he's got people around him protecting him. Well, perhaps, but then all of those people can be arrested and they don't have immunity. So you go in, you arrest everybody, you put them in jail, and then you say to the president, comply with the order. And if he's like, I'm not going to, then you've got a situation where the vice president or the people in his cabinet, those doofuses can come in under the 25th Amendment. But the thing about our courts is that their power just gets more and more and more significant the further you push them. So he can say, I'm not going to do it. Like, yes, you are. And then we go to the appellate court. He's, I'm still not doing it. Yes, you are. And then we go to the Supreme Court. And at that point, our courts are just not playing around. They're like, look, you've taken up all of this time. All the rules have been followed. All the laws have been filed. This is a federal court order, and you're refusing to comply with it. So you need to come into compliance. And the people keeping you are trying to keep it so that you don't have to. They all are in violation of that order, and we've got contempt. So everyone's getting contempt, like Oprah Winfrey style. Everyone's getting contempt. Someone won't be willing to throw their life away. Exactly, VC, exactly. Which is another thing too. And one of the things I was thinking about. So this woman was removed from her position on the board, right? It's a specialized position. It's a very, it's a very particular job that she has, and is appointed by the president, confirmed by the Senate. So my thought was, why didn't they just rush and put somebody in that position then while this was going on before the restraining order was implemented? Now they can't because this order has come out. But, they had a few days here and there. Why didn't they put somebody in the position? And my thought is nobody would take it. Nobody was going to take that position. Not only that, but having it get approved through the Senate while litigation was pending would be a nightmare. I think we already have people stepping up and saying, no, I'm not going to do it. There's only going to be a handful of people that would even be qualified to do this job. And they're already saying, we're not comfortable doing this crap. So I think that was definitely a factor. In my opinion, I think that was a factor in this situation. Yep. So we've got, yes, his immunity is limited as well. So, and he might think, I can fire whomever I want because the Fitzgerald case, that's just not true. That's not true. The Fitzgerald case, where we had someone eliminated from a position, Nixon legally eliminated him from that position. He did not violate the rules regarding eliminating that person. Here, they have violated the law. They violated federal statutes when they removed her from her position. That is, not allowed. You can't do that. There's no immunity from, you can't come for me. Well, we can if you're not following the law with the action that you're supposed to be doing here. Will it open the door for others to get their jobs back? Yes, Kim. And I think that this one, along with what's the name of the other case? I keep saying Dillinger, but that's not the right name. Hold on here, everyone. Let me get the name of the case proper here. I don't want to have the wrong sites. Just one moment, please. Here we go. What am I'm looking at? I liked how this judge was referring to that case so many times. I guess it is Dillinger. Anyway, it's hand in hand with this one. So this is a special counsel who was appointed and fired. This case goes hand in hand with this case. We also have the National Labor Relations Board person who was also fired. So these three cases all would work together. And the courts are watching what the other judges are doing here, and they are going to put this together in order to make like a super case where they put it in front of the Supreme Court and we're like, do your job, or else you're gonna have problems. Immunity doesn't allow him to do whatever he wants. He still needs to follow the law. It really just means he can't be prosecuted. Exactly right, John. You can't sue him. You can't say unlawful, wrongful termination of my job when he has legally terminated you from your job. You can't sue him for that. And you can't, prosecute him for criminal acts. We don't have a criminal act here. This is all civil administrative stuff. So this isn't, there's no crimes. So that immunity decision isn't even applicable because it's only applies to criminal cases. All right. So those are the situations where we have immunity. You can't sue him when he's doing his own job. You can't prosecute him, which, the DOJ wouldn't prosecute anyway. So that immunity is off the table. And you can feel free to tell everybody about that. Pass it on. Pass that information along to as many people as humanly possible. So people can get that. All right, everyone. With that, I will go ahead. We've got our, oh my gosh. Oh, this was so fun to go through. And I appreciate you all coming and hanging out. Can still overturn his decisions. Absolutely. Absolutely. Yeah, say that again. Okay, so here's the deal with immunity, all right? With the immunity cases, you cannot sue a United States president for a decision that they make while president. That's one of their duties. So that was established when President Nixon fired somebody from their job. And he fired them in accordance with the law. And that person sued him and said it was an unlawful firing. And the Supreme Court said, no, he was just doing his job. You can't sue him. Number one. Number two, the immunity case that was just this past summer has to do with you cannot charge a president criminally for an official act. What we're dealing with here, all of these cases are all civil, and the Department of Justice has this protocol where they don't charge presidents of the United States with crimes anyway. So that immunity decision is not even going to be applicable while he is president. All right. You might go back later and be like, oh, you did this, it was illegal. That'll be argued after he's left office. But while he's in office, we don't have any kind of criminal immunity questions. And he still has to follow the rules. So Nixon followed the rules. Here it says you can't terminate somebody unless you have 1, 2, or 3. They didn't have 1, 2, or 3. So, you screwed up. So get yourself sorted out. And you could do, yeah, exactly, Achilles. Fitzgerald. I shake my fist at Fitzgerald for the rest of my life. But, that's the thing. If they would have just done this legally, they would have been able to be fine. They could, again, do all of this stuff, but they didn't want to go through and follow the rules. And so now, there's lawsuits up the wazoo because of it. His immunity for prosecution doesn't give him the right to do things outside of the law, or the courts can overturn it. Correct, unless it's part of his official duty. But none of this is going to be applicable anyway, because he's not going to be charged criminally for anything while he's in office. All right. That's kind of the kicker here, is that the DOJ will not charge him while he's in office. So, oh, thank you you're so sweet. Yes. I'm working on the memberships, everyone. They do have a few little extra perks in there, and I'm getting the perk packages put together right now. There's just a lot going on. I'm maintaining a wall of lawsuits. So with that, everyone, I will go ahead and sign off for tonight. Thank you for coming by. And if you missed the live earlier today on TikTok, I will be uploading that again within the next couple of days. I have several lives that I still need to upload here on the tube. And also, Yeah, there's just a lot. There's a lot. I'll get it done as quick as I can. I'm a one-woman show here, so I'm doing the best I can, everyone. Take care. Have a great night, and I will see you all again very, very soon. Again, thanks for coming and hanging out. And as always, moderators, oh, so thankful for you. Every day I'm thankful for you, moderators. Take care of yourself, everybody.